respected Dr. Agnihotri, my esteemed colleague, Mr. K.B. Jalali, friends from the bar, and respected guests. Mr. Agnihotri was quite home with the historical perspective, which dates back even to the BC, when it is said that the grandson of Brahma, who was the first king who ruled Kashmir, and this kingship of Hindu carried on about 4,500 years, and followed by those invasions which he talked about. Now I'm picking up a thread from what Mr. Jalali started with, that is instrument of accession. Today's discussion may not end up conclusively on issues which are very contentious, but we can make some effort to put the correct perspective legally, because I'm not saying anything about the politics of it, because what is sometimes legal may not be political and vice versa. The instrument of accession was signed. There are certain sure things which I am going to state. It was signed by the sovereign ruler, no dispute on this. Did get delayed by about 2 months for the reasons. There were different reasons. Some writers have also different views on this. One is that they were looking into the geographical contiguity and the majority Muslims who were the state subjects. State subject was already in place. And second was, there was a fear, that is the view which is presented by the sympathizers of Maharaja, that he feared some civil war being waged. Anyway, it got, ultimately, what is the point in issue? The instrument of accession was given to the dominion of India, because British paramountcy had to come to an end, and 1935 Act had perceived the transfer of power and how it would start from the princely states and the provinces governed by the British India. One of the states being Kashmir, Jammu and Kashmir, where we had a Dogra rule of 101 years, in which we enlarged our boundaries up to Waziristan and to Tibet by great warriors. And that was the gain of that Dogra rule. After the instrument of accession was done, the Maharaja, he was a sovereign ruler, he surrendered the territories which existed at that point of time, and included amongst that also the area which was occupied by the Rangers, Kabalis. So therefore, the ingredients of Article 1 of the Indian Constitution, which talks about the composition of states, and Jammu and Kashmir finds expression at number 15 state in that. So we should put at rest one controversy, that by virtue of Article 1 we became the part of a Union of India. Article 370 and Article 1. Article 1 is not dependent on 370. Article is independent of 370. So one thing is put at rest, that the Jammu and Kashmir, through the instrument of accession, by a sovereign ruler, was made a part of Indian Union. What followed thereafter? That Sadr-e-Riyasat was made. First there was the interim government 1948, in which Sheikh Muhammad Abdullah was appointed. When Maharaja by proclamation declared that his son Sadr-e-Riyasat, as it was known those days, would carry out all the functions which I as a ruler was doing with the aid and advice of the Council of Ministers. Now what happened? In 1949, somewhere in June, he nominated 4 representatives, represent them the J&K state in the National Constituent Assembly, where you must be remembering that Mr. Iyengar played a great role in that. And they went with a viewpoint which was brewing up, and what had transpired, that remains a mystery. Whether what followed thereafter was some Delhi Agreement 1952. Coming back to the Constituent Assembly, National Constituent Assembly, it is said that a viewpoint was put by Mr. Iyengar and a bill was moved, and the Article 370, which in the Constituent Assembly was discussed as Article 306, was discussed, and subjects which were covering, which instrument of accession covered, beyond the subjects which were covered by instrument of accession, were to be left with the state of Jammu and Kashmir and to their will. Now what happened? I am going in historical perspective, so for legal point of view, because it's a question which will later come into everybody's mind. After all, why it is a vexed problem. So on 25th date is important, November 49, because next day, 26th November, was a law day when the constitution had to be adopted. Another proclamation was signed by Yuvraj Dr. Karan Singh, declaring that Constitution of India, which is shortly going to be adopted, it shall, insofar it applies to the state of Jammu and Kashmir, govern our relations with that of Government of India. Now, in respect of other states, there was a merger agreement. We should not deny these historical facts. Once the instrument of accession was signed, 1935 Act, Independence Act, had to come to an end the moment all these princely states gave their consent and surrendered their territories to dominion of India. According to them, the life of instrument of accession was till the 1935 Act existed, and thereafter came the 1947 Act. According to those who are in favor of retaining Article 370, they say that the instrument of accession which was given to the Dominion of India, not to the Union of India, because it did not exist. The India had to become a republic first. It became republic on 26 January 1950, and in a very critical sense, one becomes republic not only by the adopting of the constitution, then unless the first general election was held. That was done in 1952. But we leave that as it is. According to them, those who support this view, that there was not additional instrument by which the further relations could be defined with the Union of India, and that's why they call that the instrument of accession has been substituted by Article 370. I am giving total abstract position of law, not making there is no political angle involved in it, because I am being called to only explain what are those challenges. Insofar this Article 370 is concerned, the President is vested with powers to pass on the laws to the state of Jammu and Kashmir as are applicable to them. Firstly, on the subjects which are contained in the instrument of accession, and secondly, from the union list with such modifications which will be with the concurrence of the government would come. Now thereafter there were many interpretations what government means, government of the time, because the word used has been government of the time. So therefore when there was a governor rule, many things were put to us also as a legal team. My predecessor friends, just V.K. Gupta, Adv journalist Pramod Kohli. And when my turn came, I also gave my view. Whether during the governor rules, because the President of India assumes when it's a president's rule beyond 6 months, because there was an impasse on this issue that after governor's rule, how the president rule can come in. So we gave those opinions and said that it can be referred to as, instead of 6 months, we can do 1 year. Because the rest of the India, when the president rule goes beyond 1 year, it has to go to the parliament and resolution has to be. All constitutional development has taken place right from the inception when Constitution application 1950 order was passed. And my friends, you must be knowing I'm pointing to colleagues, that the 1950 application to Jammu and Kashmir did not have fundamental rights for the state of Jammu and Kashmir. And those, what subjects, why it was substituted subsequently by 1954 order. That is very important for any law student to understand. 1950 was falling short of very, very important constitutional rights. For instance, the Supreme Court jurisdiction was confined to Article 131 only, which is pressed into service only when there are disputes between the states and Supreme Court resolves them when a reference is made. Then the representation to both the houses of the parliament were not sent by election, but they were appointed by the president. Election Commission of India had no jurisdiction except for the post of vice president and president. And citizens of J&K were not deemed to be citizens of India. No compensation was given. There were very sweeping agrarian laws and brought in by late Sheikh Abdullah, for which he earned credit. A laudable job was done, that the land reforms were done. Big Land Abolition Act was passed. You must know as lawyers. That time, Big Land Abolition Act, when the limit was placed at 182 canals, there was no provision for the compensation to the people whose lands have been taken beyond the ceiling here. And it was 1954 order, application order to Jammu and Kashmir, which substituted, which brought fundamental rights, which brought compensation to those whose lands had been taken beyond the ceiling of 182 canals. And the emergency laws were not applicable. Now, 1954 constitutional development, it's a big leap in the history of India, which tried to integrate India with Kashmir by passing through the window of Article 370 all these laws into state of Jammu and Kashmir. Now let us go. I will leave because there has been a lot of constitutional development. More than 290 articles have already been passed into the state of Jammu and Kashmir. In my time, when I was Adv Jalali, I also got passed at least 20 laws. Financial integration and other things in the governance. It's a pointer that 1954 order was a watershed in the constitutional development of Jammu and Kashmir because it brought about integration of Jammu and Kashmir with the rest of the country. Now let us come to a most contentious Article 35A. Its surreptitious inclusion in the Constitution is a matter which Supreme Court is already seized of. I will, as a student of law, I can only say that it has no constitutional origin. And this law, by bringing in 35A, let us examine what are its fallout. Negative and positive both I am going to say. Negative fallout are that Article 16 and 19 1F became casualty, particularly when the properties laws are still intact in the state of Jammu and Kashmir. Section 51 was inserted in the J&K constitution. What they say, that 35A provided a cover to bringing in the model of J&K constitution. J&K constitution had very vulnerable certain provisions which were vulnerable to challenge because they were discriminatory, and that's why the matter is pending before the Supreme Court. Gave a cover that nobody on the basis of discrimination, that he being a citizen of India does not have a reciprocal rights as are given to a citizen of J&K state, I mean permanent resident, because that challenge would have been a challenge which would bring in the parity to those who are citizens of India and yet cannot buy the property in the state of Jammu, cannot get employment. Now, now this constitution having come into existence, and the constitution preamble opens with that it defines the relationship of Jammu and Kashmir with the state of India. It opens with that preamble. This was adopted in November 56, but prior to, what a good thing has happened, a resolution by the Constituent Assembly was passed that we are part of the state of Union of India, that those are certain points which need a debate, that it is not a closed chapter altogether on Article 370. If after the insertion of Article 370, so many constitutional application and so many these provisions of constitution were brought in, that is a happy situation. Now, section 140 is a voter eligibility, that was also inserted. Who is eligible? Who is a permanent resident of Jammu and Kashmir? Then the Transfer of Property Act, Alienation of Land Act, Land Grants Act, Land Development Acts. There the rider was placed that you cannot buy a property if you are not a permanent resident of this Kashmir state. Now the permanent resident was defined in section 6. Now, what is the people who think that in the eventuality of 35A going, these all provisions including section 6 will be exposed to a challenge, which is those who advocate that 35A should be kept. But legally speaking, that has no origin. It is a surreptitious inclusion. It has to go, lock, stock and barrel. Then there is now the question arises, what is if the amending power of the Constitution is 368, and there are certain riders placed under 368, insofar state of Jammu and Kashmir is concerned. Now the 368 has undergone many changes ever since it was incorporated. The first challenge was the Constitution this amending power of the Constitution, because in other countries there is a separate body which looks into the amending powers. It is not the same parliament which does. And that amending power was upheld by the Supreme Court in the Shankari Das case, and in order to upstage that judgment, then there were certain amendments made, and then led to the Goloknath's case, and from Goloknath to Keshwanand Bharti to Minerva Mills case. Ultimately, what I want to say, in Goloknath's case, this goes into the perspective of political statement that those are being made, that accession goes if 35A is absolutely wrong. You cannot buy this. The reason is, in Golaknath's case, there was a suggestion the fundamental rights cannot be amended, and if you have to amend, you have to resurrect the Constituent Assembly of India, which is normally an argument given here by the political shades of the state, that you will have to resurrect the Constituent Assembly of the J&K in order, if you want to bring any change or pass in law, which without the concurrence of the Constituent Assembly cannot be passed into the state of Jammu and Kashmir. And that ruling in Golaknath's case, saying that if you have to change the fundamental rights, you have to go back to the Constituent Assembly, that was repelled by a subsequent judgment, and they upstaged it saying that this is all nonsense. So therefore any argument, political, which is being spread, that if the instrument, you have to go back to the Constituent Assembly, that's how totally humbug. We don't take it, and all law students are my friends, colleagues who are sitting here, they will appreciate that. This is the only one conclusion that I can draw today. Leaving 370 to a discussion, because that Supreme Court is already going on, because I am also wanting to find out that in the eventuality of 370 being scrapped, is there any need to sign any other instrument which will determine, because it is not a free fall, that if you disconnect one arrangement, how it is going to be continued as if in the other states of India. So political slogan is very good, but we have to find out solutions. 35A has to go. It has no constitutional origin. It has not come by the amendment power, because they normally use, there was an argument, I could go through those papers I saw in Supreme Court. The one argument is given that General Clauses Act, which gives a power to issue, gives a power to amend also. The one who issues, who can alter it also. Power of amending would mean alter, and also altogether make a radical change in the law. By using the expression radical change, they mean that if there was not any provision, one can be made through by the president, by the presidential order, which is again a misnomer, which cannot be done constitutionally. Then I have one thing which my esteemed friend also said, 1975 Accord was done, which is a very important to note. There was I would have to just read that for you. 1975 Accord was another watershed in the sense. But the one main point was that 370 got a further lease through the 1975 Accord, because they all reiterated their faith in 370, because that was the only, according to the constitutional experts, that was only the constitutional link between J&K. So reiterating that, yes, it will. Now it is very important to notice one thing. Clause 5, as an arrangement reciprocal to what has been provided. Clause 4 are with a view to assuring freedom to the state of Jammu and Kashmir to have its. Now kindly see, it's a very important. Its own legislation on matters like welfare measures, cultural matters, social security, personal law and procedural laws, in a manner suited to the special conditions in the state. Tangibly it is nothing. It is agreed that the state government can review this law made by the parliament or extended to the state after 53 on any matter relating to the concurrent list, and may decide which of them, in its opinion, needs amendment or repeal. Thereafter, appropriate states may be taken under Article 254, conceding the power of the parliament to make laws for the state of Jammu and Kashmir under 254. the grant of president assent to such legislation would be sympathetically considered. Kindly see what, is there any mandate? So in a way, 75 accord was done, which was little softer, and there was an effort to integrate more vigorously. Then there was no promise. There was one carried saying that we shall review those laws. They said there was no conclusion drawn on that point, and therefore it was left as it is. The crux of today's discussion is that there are lots of challenges, legal challenges, which we have negotiated in the past also, and it's a democracy. Legal challenges are thrown, they are met with the machinery we have. We faced them during our tenure during the 90s, early 90s, when the TADA, AFSA, this Public Safety Act, which is known as the National Security Act, was challenged in the state of Jammu and Kashmir wing. They all sustained those, all petitions were dismissed. Laws are concerned, which we call they are draconians. But they meet the situation. Because once a delegation had come, my friend would be knowing, he was also in the thick of those. A delegation of 10 ambassadors had come to Kashmir to assess the situation and take the report of human rights violation and all. They were addressed by the police chief and all that, and finally I was told, you go and talk to them. So we went and talked to them. They had brought about 200 orders of contempt petition saying that in this part of the land there is no law. The court orders are not respected, our detainees are not left out. Although there were 10,000 detention matters, that's a record which team of Jammu lawyers, which I had the honor of leading, and my predecessor also. We fought those cases in a grave, dangerous situation. And in those days, when these challenges were thrown, government machinery was, despite militancy was there, they did a hell of a good job. And these ambassadors told that, look, there are 200 contempt petitions against you, you don't obey these orders. I said only one thing, there was Attorney General of UK also sitting with us, she was a lady. I told them that it speaks about the freedom of judiciary, independence of judiciary in this country, that they have issued 200 contempt notices against the highest in the power machinery. So she smiled and thought that, though it's a very clever answer, I told her that this is the only court in the country which entertains habeas corpus petitions from Pathankot to Uri, one and to another. Do you see any human rights violation in that? Second question was, I said, I have come today to meet you, there's a hartal outside and band. Is that not a human rights violation? We had to move with a paraphernalia of security to reach to you people. So with these couple of answers, they were very satisfied, and later went and directed them to see the migrant camps. I requested them to see the migrant camps here, and the situation was resolved, and they went with a good impression. The last word is, 35 is vulnerable to challenges, and Supreme Court is seized of the matter. But so far J&K Constitution is concerned, this has the Santosh Kumari's case, decided in December 2018, in surfacey matter, has held that J&K Constitution is not sovereign, in the sense they are using this word, but it is subservient to the Indian Constitution. So there is no worry even if J&K Constitution stays, because Section 3 of J&K Constitution, that is very important to read. It says that state of Jammu and Kashmir is and shall be the integral part of it. So there is no worry, don't think that any instrument of accession is going to be revoked and then heaven is going to fall, nothing is going to fall, only we have to deal with 370. How? and in what manner it stays or goes or is modified in the sense for a total integration of Jammu and Kashmir, the state and the will of the people. Thank you very much.
नमस्कार एवरीबॉडी। पूछने को तो बहुत कुछ है लेकिन टाइम बहुत कम है, तो मैं केवल एक छोटा प्रश्न तीनों पैनलिस्ट से करना चाहता हूँ। सबसे पहले हमारे जलाली साहब से मैं सिर्फ ये क्लैरिफिकेशन मांगना चाहता हूँ कि एज पर कॉन्स्टिट्यूशन ऑफ इंडिया आर्टिकल 1 देयर इज नो मेंशन अबाउट द मर्जर, एज फार एज आई नो, सब जानते हैं। लेकिन इसके लिए आपको ज़्यादा कुछ कहने की भी ज़रूरत है इस वक्त, क्योंकि मुफ्ती साहब, मैडम मुफ्ती राधा अब्दुल्ला और करंटली आज 2 दिन पहले हमारे डॉक्टर करण सिंह साहब ने यह कह दिया कि ये मर्ज नहीं हुई है। विल यू प्लीज मर्जर, इसको प्लीज क्लैरिफाई कीजिए। क्या हमारी स्टेट जो है अभी भी चाहती है मर्ज करने के लिए? एक्सेप्शन काफ़ी नहीं है, लेकिन आर्टिकल 1 जो आप इंडियन कॉन्स्टिट्यूशन का है उसमें देयर इज नो क्वेश्चन, कोई रीजन नहीं है कि मर्जर की बात है। काइंडली
मैंने अर्ज किया है एज ए स्टूडेंट ऑफ लॉ, मैंने एक व्यू पॉइंट बताया है कुछ लीगल एक्सपर्ट्स का, मेरा व्यू पॉइंट नहीं है वो, लेकिन अच्छी ईमानदारी से कोई बात करना जो है वो बहुत ज़रूरी है। ऐसे तो अगर मैं पॉलिटिकल स्टेज पे होता तो मैंने यहाँ से नारे शुरू करने थे 370 हटा दो। ये हमारी इच्छा है, कांक्षा है सबकी कि इंडिया का टोटल इंटीग्रेशन हो जाए। आपकी तरह मैं भी शहरी हूँ और मेरी भी यही इच्छा है कि हमारा भारतवर्ष एक जुट खड़ा रहे। जो पॉलिटिकल हिस्ट्री आपने सुनी और जो कॉन्स्टिट्यूशन हिस्ट्री इंडिया की हुई, जो 1950 में हालत थी वो 1954 में नहीं थी, जो 1954 में थी वो 75 में नहीं थी। 370 को आप रखिए। मैंने ये कहा था, शायद अगर आप समझें, कि आर्टिकल 1 जो है वो इंडियन कॉन्स्टिट्यूशन का डिस्क्राइब करता है टेरिटरी क्या क्या बनेगी यूनियन ऑफ इंडिया की और कौन कौन स्टेट उसमें है। मैंने ये बताया कि J&K उसमें एक शामिल है। ये जो आर्ग्यूमेंट कर रहे हैं कि 238 के तहत जो पार्ट बी स्टेट्स में उनको वो अप्लाई नहीं करता स्टेट ऑफ जम्मू एंड कश्मीर को, लेकिन 238 को कॉन्स्टिट्यूशन से ख़त्म कर दिया है, एबॉलिश कर दिया है, तो वो कंडीशन ही उड़ गई है। इसलिए हम उस शेड्यूल में फॉल करते हैं जो बाकी उस वक्त 22 स्टेट्स थी इंडिया की, उसमें हमारा 15वां नंबर है। इसलिए वो आर्गुमेंट उनका गलत है। और जो इंस्ट्रूमेंट ऑफ एक्सेशन है वो एक जैसा ही हर जगह हुआ है, कहीं भी कंडीशन नहीं थी। चूँकि मैंने एक थोड़ा सा एक थ्रेड पकड़ना है आपने, इनका जिन लोगों का आर्गुमेंट ये है कि वो डोमिनियन ऑफ इंडिया 1935 एक्ट के तहत वो यूनियन ऑफ इंडिया, इंस्ट्रूमेंट ऑफ एक्सेशन, डोमिनियन ऑफ इंडिया सबने हेरिडिटरी रूलर्स ने दिया, सबने इंस्ट्रूमेंट ऑफ एक्सेशन सेम दिया। उन स्टेट्स ने मर्जर किया। हमारी स्टेट की पोजीशन ये थी, एक तो हमारा इंस्ट्रूमेंट ऑफ एक्सेशन 2 महीने डिले हो गया, 2 महीने और 11 दिन। और मेरा आर्गुमेंट है कि 1935 एक्ट तो was coextensive or coterminous with the submission of that instrument of annexation, and that controversy must end with that. मेरा पर्सनल आर्गुमेंट है, इसलिए हमें जरूरत नहीं थी मर्जर। ये मेरा है, लेकिन जो विशेषज्ञ कहते हैं मैंने उनका व्यू पॉइंट दिया है।
एक बार इंस्ट्रूमेंट ऑफ एक्सेशन पूरे भारतवर्ष के राजाओं ने कर दिया।
मैं आपको जवाब देगा। एक आर्गुमेंट था जो आपके पॉलिटिकल बॉसेस के यहाँ कहते हैं कि साहब कॉन्स्टिट्यूएंट असेंबली को पूछ के ही सब कुछ होगा, उसको तो रिसरेक्ट करिए, जब दोबारा जिंदा करिए। मैंने आपको बताया कि हिंदुस्तान में गोलकनाथ के केस में ये जब आर्गुमेंट मेजॉरिटी जज ने 11 जज की पीठ ने 6 में से उनने कहा था कि हाँ कॉन्स्टिट्यूंट असेंबली को रिसर्ट का अगर हमने फंडामेंटल राइट चेंज करने हैं, तो अगर हमारे कश्मीरी भाइयों के फंडामेंटल राइट चेंज करने हैं अकॉर्डिंग टू वो तो फंडामेंटल राइट हमने रेस्टोर किए, उन्होंने कहता बात तो फंडामेंटल राइट थे ही नहीं, वो तो हमने 54 के ऑर्डर से किए हैं। वो आर्ग्यूमेंट ना तो कॉन्स्टिट्यूंट असेंबली थी तो ना, अब क्या कहते हैं, एक और व्यू देखिए, आज राजा है, राजा का सक्सेसर फिर आया युवराज विद काउंसिल ऑफ मिनिस्टर्स। काइंडली अंडरस्टैंड व्हाट गवर्नमेंट मीन्स। I'm not going to cheat the audience here by emotionalizing with the popular way or unpopular way. Question is only that instrument of accession signed, it is final, irrevocable, दुनिया की कोई हस्ती नहीं इसको हटा सकती है, ये मैंने पहले कह दिया है। ये फाइनल है क्योंकि J&K कॉन्स्टिट्यूशन ने सेक्शन 3 में कहा हम इंटीग्रल पार्ट हैं, आप उनके स्लोगन्स पे क्यों जाते हैं? वो फेक है, वो गलत बात है। You reject it. Instrument of accession को कुछ नहीं हो सकता। हाँ उन्होंने किया था, उन्होंने किया था।
मर्द वाला डिक्लेयर कर दीजिए कि मर्द की जरूरत नहीं है, इट इज जो एक्सेप्शन है वो बिल्कुल फाइनल है, देयर इज नो क्वेश्चन नंबर।
ये जो इंस्ट्रूमेंट ऑफ एक्सेशन है, आपने कहा ये फाइनल है, ये तो किंग ने किया, आपको किंग कहिए या कुछ उन्होंने किया, उसके बाद देयर इज नो युवराज। I will object this word because once the instrument of accession is signed,
क्या युवराज?
that kingship is over. That kingship is over. राजा ने साइन कर दिया, राजा के साइन करने के बाद क्या कोई दूसरा कॉन्स्टिट्यूशन होगा या कोई दूसरी कॉन्स्टिट्यूएंट असेंबली होगी वो उसको रेक्टिफाई करेगी?
जो
प्रोविजन कि राजा के साइन करने के बाद कोई और बॉडी बनेगी जो उसको रेक्टिफाई करेगी या
जो कॉन्स्टिट्यूशनल डिबेट्स है ना, अगर आप पढ़ेंगे तो आपका व्यू क्लियर हो जाएगा।
सर दो
एक रिएट्रेशन हो सकती है,
वाला क्लियर कर,
मर्जर नहीं हुआ, कॉन्स्टिट्यूंट असेंबली नहीं रही, इसलिए वो डेड लेटर हो गया है, वो नहीं जरूरी है। देयर वाज नो, आई एग्री विद यू।
मर्जर क्या था कि जैसे मध्य प्रदेश में 200 प्रिंसली स्टेट थी,
हाँ जी,
उनका मर्जर मध्य प्रदेश में हुआ। जम्मू कश्मीर अपने आप में एक बड़ी स्टेट थी, इसका मर्जर की जरूरत ही नहीं किसी में। मर्जर का मतलब था स्मॉल स्टेट्स का बड़ी स्टेट में मर्जर होना। जम्मू कश्मीर स्टेट को पंजाब में थोड़ा मर्ज करना था, ये तो इंडिपेंडेंट स्टेट थी उसमें, इसलिए मर्जर का कोई मसले में तो आई नहीं।
यही तो कह रहे हैं।
बिल्कुल आपसे जो चीजें उन्होंने करनी थी वो नहीं हुई, अगर नहीं हुई 2 मिनट के लिए मान लिया जाए आर्गुमेंट, ये आर्गुमेंट चलता ही नहीं है आगे, ये आर्गुमेंट फेल हो जाता है इस इशू पे कि जब कॉन्स्टिट्यूंट असेंबली नहीं रही तो उसके बाद वो प्रतिक्रिया किसके साथ करनी है? नया कॉन्स्टिट्यूशन आ गया, उन्होंने इंटीग्रेट किया, आपके साथ खत्म बात होगी, दैट्स ऑल। सेक्शन 3 हैज बीन रिप्लेस्ड,
उसके बाद आएगा जो उसको
नहीं, बाकी स्टेट्स में उन्होंने एडिशनल इंस्ट्रूमेंट्स किए थे, एडिशनल इंस्ट्रूमेंट्स किए थे।